welcome everybody to this Privacy Kitchen. I'm really super excited because Laura Irvine, I heard you speak at the Privacy Space conference at the end of March about exactly this topic about damages cases, and it was a brilliant talk. It was really interactive, really funny as well, and so I'm delighted. Thank you very much for joining me as a guest chef in Privacy Kitchen. This Privacy Kitchen is about, as I say, damages that you might get as an individual or that you might have to pay as an organization, because the audience for Privacy Kitchen is those people looking after privacy for their organization. Typically not lawyers. They get something coming in and go, what is this? How do I deal with this? How much are we on the hook for all this sort of thing? And there's been some fantastic case law, as you said. And it's not about fines from the regulator, because the regulator can't issue compensation. They only fine the company. So it's really about individuals having a go at a company, and we're going to get into that. So I'll pause there. And Laura, if you could introduce yourself and the firm, and then we'll crack on.
Excellent. Thank you, Robert. And I am also super excited to be here. So I am Laura Irvine. I am a partner and I head up the regulatory team of my very Scottish law firm, Davidson Chalmers Stewart. So we're very proud that we're one of the few, I think, remaining commercial law firms that's entirely based in Scotland. However, in terms of data protection law, that is something that applies UK-wide. So I have the very exciting role of being able to work with English as well as Scottish clients. So regulatory law is what I practice in, and came from a very contentious background. And in fact, I was a procurator fiscal in Scotland, which is a prosecutor in a previous life. And then moved into a commercial law firm and started specialising in much more, my Twitter name is Posh Crime Scott, because it sums up what I do. So different kinds of
or rather, not what you do, but what you work on.
Yes, thank you. And so then I started looking and was involved in a particular data protection case, which involved an ICO fine, and was part of the legal team to represent Scottish Borders Council when they had their fine overturned. So that's probably my starring moment as a data protection lawyer, but it really started off my interest in this topic. And of course, the GDPR came along, and then I became a Law Society of Scotland accredited specialist in data protection law. So very delighted to share some of the stories that I have from that and the experiences that I've got, in particular in relation to the contentious side of data protection.
Fantastic. And that's why I'm so excited, because you've got fantastic experience. So I'm excited about the cases we're going to talk about. So what is a typical data subject claim? So that IT security ops compliance professionals looking after GDPR at their organization, going about their day job, and someone goes, Laura, we just received this email, or this has just happened. What are the typical sort of claims that individuals can make against the organization that hit that person's desk?
So classically would be email sent to the wrong person by mistake, containing lots of sensitive personal data. So easy to do, so easy to avoid, actually, in certain circumstances. And then what do you have to do? Well, one of the things you have to do is tell the people whose data has been disclosed to the wrong person. And that's the start of your help. I've had a data breach, and will there be a claim? Will there be claims? What level will those claims be, and how much do I need to worry?
And then also there's some letters that, again, at Privacy Space, everyone's talking about them. Data protection professionals are, I think it's pretty shady stuff, really. There's occasionally they'll get a cookie dropped that shouldn't have been dropped before consent. It's very easy to do. The tools that people use aren't perfect. They might have it set up well and things change, what have you, but obviously it's not right. But they then send a letter saying, you dropped this cookie on me without consent. I want X dollars or pounds, what have you. And people go, so that's the sort of have you come across those and the reactions to those as well?
Absolutely. That seems to be a little cottage industry that's arisen. And it's so easy to go onto a website and find these cookies, which are being placed without consent, and that is a requirement under PECR, under the Privacy and Electronic Communications regulations. But it's something that I think has changed over the last few years, or certainly the attitudes and the guidance from the regulators has changed. And so we're seeing better compliance, but still not perfect compliance. Even some of the providers out there will give you tools that don't quite meet the requirements of the law. So these letters, yes, I have seen them, and clients have come to me and said, well, this is a lot of rubbish, isn't it? And I have to say, actually, you've got to be careful here. So the first thing we do is sort out the website, make sure it is compliant. But the reality is that it would be, in my view, difficult to defend a claim against cookies being placed without consent. And there's two, I think, grounds for those compensation claims. One being the distress, which seems very unlikely, but actually, when you dig into what happens with particularly third-party analytics, which don't tend to gather personal data for the website operator, but that information is then shared with third parties who have lots of data about all of us. I do believe that some of these large tech companies know more about me than I know about me. So in their hands, it very often will become personal data, and it will be used to inform lots of activity that they carry out, typically advertising, but it can also be political advertising. It can be sensitive health data there as well, depending on the website.
But one of the things you mentioned there was really appropriate. We haven't, and we'll, I think it's a good time to mention this, that it's not just GDPR, as you say. So cookies are PECR in terms of whether you need consent or not. If you need consent, GDPR sets the track. But also there's been, in the cases we're going to talk about, some other causes of action. And we don't want to go too lawyery on it. Do you want to just take us through a couple of those causes of action that people are talking about, and how maybe we can not worry too much about them with the way the case law has gone?
Yeah, sure. So I suppose there's two categories of breaches. And the first one, which is less likely to cause trouble, will be this misuse of personal data because it's been disclosed on purpose. So classically, a media organisation. We could talk about Wagatha Christie, Robert, but I don't think we get caught up with that.
That's another thing,
the intentional disclosing of information by organisations, and that becoming misuse of personal data. I think that probably sits separately from what we want to talk about today, and has been closed off to some extent. Although there are a couple of cases we'll talk about in terms of the processing of inaccurate data, which is a head of claim under the DPA. However, it's being treated slightly differently in terms of levels of compensation, I would say. But the other category, of course, is the accidental, the email to the wrong person, or some kind of cyber attack, which has led to information being out there. And so that's been dealt with slightly separately and more under Data Protection Act compensation claims, which at the moment seem to be at a lower level than
which is a great segue in. So the big question is, are data subject claims massive liability? When this comes in, either it's someone says, well, let's deal with the cookie one first. You get a letter going, look, you dropped this cookie, here's a screenshot of my report, and you dropped it, it needed consent, you didn't ask for it, I want £5,000 or whatever, or I'm going to take you to the High Court. What's the real sort of value of those claims, and what should the person immediately panic? Like, take us through the context of that, and the sort of the way people might think about what they think about when they receive that.
Sure. So starting off, I suppose that level of claim, I think, is quite important in relation to how you deal with it. And obviously you would want to negotiate any level and start and drop that down. However, the thinking then has to be, well, if I simply pay this person some money and they go away. Is that going to be cheaper than ignoring it and they might go away anyway? And of course, that's a possibility. Or allowing them to raise an action in court. And of course, the complexity of that action, the level will depend on the level of compensation that they are seeking. So, sorry, I'm Scottish, so we have something called simple procedure, which is very easy for individuals to do themselves. So you don't need to instruct a lawyer to do that, and you can do everything online. But the maximum claim there is £5,000. So that was a good figure to choose, right, Robert. But that is quite a high figure, in my view, for the kind of distress that would be caused by cookies, by placing cookies without consent. But and I suspect it is similar levels in England.
It is, and I think one of the things as well with a small claims court, which it sounds like the same sort of thing in the county court, the small claims court part, it's limited to up to 10k, but also you've got a very fixed costs bid as well. You don't really recover many costs. From looking at the cases, it seems that sort of £750 is almost like the standard damages people do in county court, or it almost feels like it's happened by default. Like, you know.
Yeah. I suspect that is the case. Yeah, that's just been a figure that's plucked out of thin air.
But then they're not going to get any more than that in costs. So if they're lawyered up, then they're going to have to pay their lawyers anything over the £750 basically they're going to get as costs. Which suggests it's not, you know, they go for it themselves, which they could well try and do, and then it's all that cost benefit of how much time for the organisation to just deal with this.
Yeah, it's a very difficult decision, I think, to make, because the immediate reaction is this is nonsense, go away. I'm not sure it is utter nonsense. I'm not sure it's a legal term, but it's not. But then it feels wrong to settle as well, because these people are not really genuinely distressed by these cookies being dropped, or I doubt that. But the whole ad tech in the background is something that needs to be addressed, and I feel quite passionately about that as well. And actually, it's been an incentive for certain clients of mine to make sure their website is compliant.
Oh yeah, for sure, yeah.
And perhaps the better solution would have been the ICO to encourage that rather than these claims letters. Yep. However, they exist, and so there's the utility. They're an incentive. They're an incentive as well for us as advisors to say, you know, you do need to sort your cookies out. Don't leave this. And then if they have to pay someone to make them go away, that kind of nominal amount of money, then fine. I suppose the other risk is, though, that is there a band? Is there a group of people who communicate? And that would concern me, that if I advised a client to say just pay them the money and they'll probably go away, are there other people in the background?
Have they got a friend there going, oh, you've paid him $750 or her $750, I want my $750?
Exactly. And that could add up to a lot more than 5,000 or whatever.
Because if they didn't start, so I think this is a good point to look at those cases that you were mentioning that started in the High Court and how the High Court reacted to it, because it's very, very different there, isn't it?
Yes, well, again, not an English lawyer, but my understanding is that the damages in the High Court will start at 100,000, which in terms of a data breach claim is extraordinarily high. There's been the big case was Gulati, which involved the News of the World, phone hacking. So some of those damages claims, which weren't data breaches, but were that sort of misuse of personal data, the levels of damages there were huge, and that was because of what was happening to these individuals, extremely sensitive information about them and their families, and then being published in a newspaper for all to see.
And it had been criminally obtained, and
very, very distasteful. And so those were unusual situations. Not all of us are celebrities, although I aspire to be such.
Maybe after this.
Yes, but the levels of damages are very rarely going to get to that £100,000 level. But there have certainly been a string of cases that there are lawyers who have attempted to bring those cases
And the judges have been pretty ripe in some of the words they've used.
Yeah, scathing about how this does not reach the de minimis technical term level, far less the levels that one would expect to see in the High Court. So sometimes they will say, off you go to the county court. That's a much more appropriate place to deal with this, but giving as well their view on how trivial perhaps this is, and whether or not it reaches this threshold of which we as lawyers call the de minimis threshold. But essentially, you've not even, there might be a little bit of distress here, but it doesn't reach the levels we're going.
So I think if somebody tries on a cookie claim to go to the High Court, I think they're just not going to get there, because they're never going to get 100K on a cookie claim. And so best case scenario they can hope for is it gets pushed down to the small claims. Worst case scenario for them is the judge gives those scathing comments and he or she knocks it out altogether and strikes out the claim. But they're probably going to just get pushed down to the county court, but then they'll have spent a load of cash in legal fees and a load of time in the High Court at that point. And so let's turn to look at the other one that we wanted to look at, which was the breach, where somebody is informed by a company, say that, look, I'm sorry, we sent your details to the wrong person, like you mentioned. And let's have a look at that school fees one, where a law firm sent a demand for payment of school fees with a schedule of how many fees had been paid and how many hadn't, with the name of the child and the address and the school and everything, to the wrong person. Can you take us through a little bit on that one and the sort of the repercussions of what people said on that one?
Yeah, so I mean, that's the one where there are very scathing comments from the judge. So this was raised in the High Court, and so the damages being sought were high, and the actual sort of description, if you like, of the distress the judge felt was exaggerated and just implausible. And this is a phrase, frankly, inherently implausible. That was what the judge actually said, and just no real basis for being in the High Court. And in fact, this was the one that was kicked out entirely, and it was the the law firm that had sent the claim in error was awarded costs. So
that a really bad film, because just for people who don't know, when you go to the small claims court, your costs are all limited. But when you go to the High Court, if you lose, the judge can say, well, you've got to pay the winning party's fees, sort of 60% of it or whatever, on average. And that, can be a lot in the High Court. So and in that case, they went saying that their life had been made miserable and they were feeling ill from the stress of knowing that someone had this detail, even though the person, I think, had deleted it within something like 24 hours. And the judge, I think, said, look, it isn't even that sensitive. This is what I think is an interesting link to the cookie cases. The judge said it's not even that sensitive amount of data. Yes, it's name, address, and the fact these school fees are there and the child's name is school, but actually that's not enough to give a reasonable person the heebie-jeebies and make them feel ill and all this stuff, sort of get a life type idea.
I think so, yeah. So like he mentioned, I'm saying he, it might have been a she, the judge mentioned, it wasn't bank details, it wasn't medical information, and that's the sort of stuff, bank details could be used to damage you. Medical information, we just instinctively don't share that. And it should not be released in that way in mistake. But this was not that type of information, and it's really important to think about those issues. The other very sensitive information that I may have a sharp intake of breath if a client comes to me and says they have lost this data, copies of identification documents. Very difficult to then retain control of your identity if your copies of your identity documents are out there. So that would be very damaging. Medical information, criminal conviction information, that sort of information as well, very sensitive.
There was so that was the one with the school fees. There was another one with rent, which was an interesting one as well, where rent arrears were sent, and it was something like pages 82 to 86 out of a 300-page document. Could you tell us a bit about that one?
Yeah, so that one again, the claim was the court held that the claim was very exaggerated. And I'm looking at a bit of paper because there was various heads of claims. So one of the things that was put forward was the fact that information would somehow become known to this individual's former partner.
Right.
Misuse of private information, breach of confidence, and then there was a claim under the Human Rights Act as well as the Data Protection Act. And there was, so it was almost like the legal team there had thought, we'll just chuck everything in and the kitchen sink, and we'll work out what's real as we go through the court system. And you know what? Again, the court's very scathing about that. And I think, you know, I think for some lawyers, it's a relatively new area of law, not for us, Robert, but it does seem that warning shot, some of these claims don't really have a legal basis, and they can come from lawyers who don't really understand what the issues are. And I've had personal experience of that, dealing with claims. Actually, on the other side, there was a claim that went through the Scottish courts. In fact, it was what was then Small Claims Court, and the solicitor who was pursuing the claim didn't really understand what the issues were, and so the causal link between the breach, which he was relying on, which was the failure to register with the Information Commissioner's Office, and what actually happened, which quite frankly possibly was a data breach, but it hadn't been identified, the sort of breaches of data protection identified properly, and therefore that was an unsuccessful claim.
Yeah, so that's interesting because the message we're getting here then from these claims is both for the cookie one and for the breach one is that the other ones, like misuse of private information and breach of confidentiality and what have you, tend to fall away at the moment from the case law. It's been obviously there's very fact specific, we have to say, but mostly those are being dropped in favor of the data protection one. And then the High Court's going, it's £100,000. You're not going to get £100,000 for this. So at best case, you're in the county court, small claims, and at worst case, you know, get a life. This isn't. I'm pointing the finger at the lawyers, which would be very embarrassing if you were that law firm, one would think. And when we were talking about this session, you raised a very interesting recent case as well about bounty.
Yeah, I found that very interesting. And actually, I remember when I was in hospital having my baby, the person from Bounty coming and taking a photo, and of course you bought that, but that allowed them to get data about new mothers and then to sell that data to third parties and market to you. So that company, Bounty, was fined by the ICO in 2019, and it's quite a horrifying fine, I found. Just this, the targeting vulnerable women who just had babies, or even pregnant women. They would give you sort of free stuff in exchange for your information, you know. But what was not clear was what they were then doing with that information. So it was a lack of transparency and certainly unfair processing of that data. And then you're at that vulnerable stage where you absolutely have to buy everything going for that new baby, and they target you with advertising. So also,
I remember it as well with our kids, and I actually thought that it was like a government thing. And so in that case, they sued both, didn't they? But they went for both.
So she sued Bounty, but she also sued the trust, which was running the hospital where she'd had her baby. Bounty had gone into liquidation by the time this came to court. So there was a trial, but it was only in relation to the hospital trust. So the question was, how responsible was that trust for the actions of Bounty? And this is an interesting decision, because the court said, well, actually, the trust wasn't responsible. There was a contract with Bounty, which set in place what it should be doing, but it went off and did its own thing. So that in this case of the woman who raised the action, she had her baby, and this woman from Bounty arrived and started looking at the medical records hanging at the end of her bed, and it would appear the woman was saying, please go away, and she clearly had noted information. So the woman made a subject access request. So Bounty got a copy of her personal data and discovered they had the name of her baby, the date of birth, and the gender of the baby. So just icky, just horrible to think that that's all been recorded and what's happening with that data. And of course, the trust's position was, well, we did not authorise that. So it's unauthorised processing by Bounty. We had a contract in place with Bounty which told them to some extent what they could and couldn't do, and they went off and did their own thing. And interestingly, what sprung to mind when I was reading this was remember the Facebook fine, which was after the GDPR came in, but it was actually related to events before. So it was 500,000, which was the maximum fine, but it felt a wee bit paltry given the headlines. But anyway, that fine was about Facebook's failure to monitor other organisations' compliance with the contract they had in place with them. And I always remember thinking, well, that's a very high standard to impose on organisations. But actually, in this case, the court had said, well, you had that contract in place and there was no question about their failure to monitor compliance. And so that was all held to be enough to make the trust, the NHS trust, not responsible for that processing activity that was going on.
So NHS have a contract with Bounty, allowing this private company to come in at a really key time, grab what feels very personal, sensitive data, use it for marketing with no transparency. Bounty go into liquidation, default judgment against them, and the NHS are let off because they say, look, you've got to have medical records at the end of the bed. That's reasonable. Otherwise, you wouldn't be able to get the job done. They had contract in place, frolic of their own by Bounty. I think there's also a comment in the judgment, I believe, about the fact that the judge thought that in that case, it wasn't actually very high level information anyway. Even the name and date of birth of a baby isn't necessarily something that's super, super sensitive. And this is also another thing about personal data. There's a lot of emotions around it as well. Yeah. And I think these high court cases are showing a lot of robustness on the part of the judges. That we were talking about, we sort of mentioned frolic of our own. I'm conscious of time, but I want to just, before we get on to the sort of other bits, Morrisons, the Google case and your Trump case. And there was also a Trump-Russia dossier case. So the Morrison case was a frolic of their own case. So maybe we sort of start there. A very quick one on Morrisons.
Yes. I think Morrisons has been talked about to death. The Supreme Court judgment came out at the start of lockdown, you'll remember. So it was one of the most exciting things for data practitioners to look at because we're all locked up. However, the point there was, Morrisons had an employee who was disgruntled, and he worked in IT actually, but he had a copy of the personnel records of every employee because he was to pass it on to the auditor. So he had it for a legitimate reason, but he kept hold of it and in a disgruntled manner took it home and uploaded it to a publicly available website. And then even at that point, no one really noticed. And it was him that actually phoned the media to say, "Oi, look, Morrisons are rubbish at data protection." So he ended up in prison actually. Morrisons investigated. The ICO didn't fine Morrisons, so there was no regulatory fine, but several thousand of the employees grouped together took a claim against Morrisons. So the initial case was that Morrisons had breached what was then the 7th data protection principle about security. And the court said, well, no, Morrisons had in place sufficient security. I would query that was looked at in as much detail as it could or should have been. And again, there may have been an issue with the pleadings there. However, what was held to be a failing by Morrisons was the actions of the employee. So that's you said frolic of his own. The court said, no, he was an employee and he was acting on behalf of Morrisons, even although he'd, what we would call frolic of his own, gone off and done something very unexpected. So he was held, technical term, vicariously liable Morrisons were held vicariously liable for his actions, and they were initially told they would have to pay damages. And this went to appeal and then eventually to the Supreme Court, who were fascinated. So more and more they're dealing with data protection issues. But, just anecdotally, I heard from one of the senior counsel involved who said, that Lady Hale was fascinated by all of these issues. But the Supreme Court said, no, in this case, Morrisons could not be held responsible for the actions of that employee. They did say that could happen, but the facts and circumstances of this particular case were that they weren't held responsible.
I think that's a really interesting one as well. It just shows lawyers disagree, even these expert judges, with the benefit of listening to learned counsel on both sides. It can flip from the High Court, the Court of Appeal, Supreme Court. So it's not, one shouldn't feel bad about not being able to get every bit of advice right.
Yes.
And that's a bit of a group action, and which takes us on nicely to just quickly talk about Google case, the representative action. Can you talk to us a little bit about why that sort of failed and how it maybe is and isn't? Again, it's very fact specific.
Yeah, yes, and it's quite legal, so I'll try and avoid the legal stuff. But don't rely on what I'm saying here as a kind of legal analysis, because there's so much in the background of this one. So Lloyd and Google was what's called a representative action. So Mr. Lloyd took this claim on behalf of all iPhone users, unnamed, and there would have been millions of them at a certain period in time. And at that point, he said Google was scraping data from anyone using Safari on their iPhone. And it was back when smartphones were just quite a new concept. And so he, as an individual, was saying, well, that's a breach of many parts of, I presume, the Data Protection Act, and all of the people are owed damages for loss of control in relation to their data, because the complicated part of that was Mr. Lloyd couldn't speak on behalf of how distressed everyone else was, so it could never be a distress claim. And that's why the lawyers here who did know what they were talking about shoehorned that kind of concept and loss of control, which came really from that Gulati case as well, the one about the news of that loss of control. So that was what they tried to argue. But that isn't a specific head of claim under the Data Protection Act, the old one or the new one. And so when it got to the Supreme Court, they held that that wasn't a head of claim, and that the action couldn't go any further, which was a great, I think, relief to many organisations. There was a lot of claims sitting in the background, and obviously the potential for just a huge increase in those grounds for claim, which up until then were distress and damage, and so it kind of calmed everyone down a little bit in terms of those the claims. Yeah,
because if he was claiming 750 for each person, and that would be like 3 billion. I felt very much about that case that this was where the regulators failed, because to me that was that should have been a whopping fine from the regulators, maybe even 3 billion, but it should have been a fine by the regulators, not a compensation claim necessarily.
I think sometimes that's what's driving. So Mr. Lloyd was the head of which, I understand, at one point. So he has this inbuilt, I'm fighting for the consumer idea. And there would have been funders in the background for that litigation. So he wouldn't have personally been paying for that. And there's a whole industry built up around that. Interestingly, the Morrisons case was defended and by Morrisons, obviously, but there was an insurance company in the background of that, which I just find interesting in terms of the dynamics of all of these. So
that's actually a good one. I think with time, I'm afraid we'll have to come back to the Trump bit on another one. But you mentioned insurers. Moving on to what people do when they get these letters and their sort of cost benefit analysis, their next steps, what they should, okay, I've got this letter, what do I do? And you mentioned insurers, and I don't think many people really think about notifying their insurers, because it's a claim. It might fall within their cyber insurance policy, which covers often data loss and data breach and such claims. And they might often, under those policies, you get like 20K of crisis help and all this sort of thing. So can you talk to us a little bit about, in terms of the next steps of what people do, maybe thinking about insurers at the beginning, but also what are the steps they then follow to sort of react to getting one of these letters, and when they need to really escalate it up and get the team involved and all this sort of thing?
I think it's really important to look at the letters in quite a lot of detail and to work out what the claim is. And it could be, there'll be extremes. It could be utter nonsense. I like to think when I write a letter setting out a claim for an individual that I set out a proper legal basis for that claim. And actually the cookie letter that I saw did that very well, which is why they are a bit more disturbing than one would have thought. But often these claims will not really be getting to the nub of the issues. And that doesn't mean if they've been written by the individual or a lawyer, both could apply. Both could be equally as nonsense or equally as valid. And it would be up to the organisation to make that assessment, given that it will know what happened, it will know generally a little bit more about the individual, one would hope, and to be able to assess whether or not there is a real issue here, or are we getting into the de minimis category where actually we should just be telling the individual that they've to go away because there is no real basis for distress. Damages, we should actually just mention, yes, distress is a head of claim, but financial loss can also be a head of claim. And obviously that's a wee bit easier to pinpoint, but it can be. So making sure that you're thinking about it in the right way, and in quite a lot of detail in terms of the principles, and that's would always generally be the basis of any claim. You need to look at the principles. Are they breached? And not just security, but fairness, transparency, data minimization, and data accuracy. All of these principles, and I usually find that there are concerns about all of these when there's been breach.
And it's interesting recently, sorry to jump in, that I think it was the APD, we were discussing this one as well. This one was interesting because they did separate out the fine for the different principles, like you say. So it's really good advice to think about. Yeah,
definitely dissect all of the principles and think, how have we done in relation to all of these? And then in terms of quantification, as we've been discussing, it is tricky. It is tricky because there isn't a book, for example, about how much a broken leg is cost, how much is a distress cost in these cases. They are all extremely contextual and very dependent on the circumstances and the individual. But let's face it, we are all individuals, and we can have some empathy with how it might make us feel. Everyone's different, but that will be a good way of thinking about it. And then if you do have cyber insurance, check your other policies as well. Because what I've been finding is that sometimes I've been acting on behalf of an individual, and it's the insurance company that's responded to the claim. And actually, I think there's probably people within insurance companies now who are building up quite a lot of knowledge about this. And I've found them to be pretty accurate in terms of accepting liability and reasonable levels of compensation. So definitely we're thinking about insurance, which it may not be at the forefront of your mind when you're talking or thinking about data breaches.
Those are all fantastic. I totally agree. And then in terms of sort of, broadening the team, if it was obviously dropping the cookies you mentioned earlier, make sure they're not dropping it anymore. If there was a breach, is it all resolved? By that point, you probably have known about the breach anyway for a little while. So you should have gone through all the typical breach response stuff of containment and identification and all that sort of stuff. And then, I suppose escalating to lawyers as well is if you're not going to, take a commercial decision. I suppose that also comes down to how big the claim is as well.
Yeah, and then some advice, legally privileged, one would hope, which will set out what the real risks are and how you should be communicating it. And actually, that was a point that I really did want to make. You really need to think as an organisation about communicating with the individual who is upset. This is probably much more relevant before the claim is made. So if you're notifying an individual, make sure you keep them up to date. There was a case, an example of a case, one of those high court cases, which was thrown out of the high court, but actually the issue there was it was an employment contract emailed to the wrong person, another employee, and the individual whose employment contract was emailed to the wrong person raised a claim, and it was only in response to that claim he discovered that the individual had deleted the email and not read his contract.
Yes.
But that was 14 months after he'd been advised that had happened. And actually, if he'd received that reassurance the day after the breach, which was when the individual said it, his claim wouldn't have reached the de minimis threshold. But as it wasn't High Court, but the judge said in that one you would still have a claim because of that. That was the bit that was that
caused the distress, that if they'd have told them early, then it wouldn't have been. And that's an interesting segue into the Curry's TV case, where the smart TV went back and the guy hadn't deleted all of his stuff. And Curry said it's not fixable. Well, they fixed it, and then someone else had it, and £3.50 was spent on his Amazon, roughly that amount. And then Curry's refunded that and gave him a £200 token. And the judge in the case said, actually, he's been refunded his loss, so there's no loss claim, and he's actually been given quite a lot of compensation for this. So goodbye, it's like, and there was interesting discussions, but he did send it down because to the county court, because there were interesting discussions about was Curry's a controller or not, and all this sort of stuff. But the actual damages he was likely to get was zero because he'd already been sufficiently sort of compensated. So it's a really interesting point you make as well about, when these breaches happen on the breach side, putting in place identity loss insurance for people, telling them what's happened, telling them it's been deleted, it's the remediation measures you put in place, maybe making an ex gratia payment, even no matter how small, depending on how many people there are, could really affect the claim going forward into the courts.
Really important. And I think that Morrisons did do take a lot of care over their employees post that incident. And of course, we never got to the stage of seeing what each individual would have been awarded in compensation due to the Supreme Court case decision, which is a great loss to us in the data protection community. But I have absolutely no doubt that all of those remediation measures would have been taken into account and minimised any of these claims.
Absolutely. And so one thing we want to do is change with the reforms, the DCMS reforms and the Brexit bonus and reforming UK data protection law. Do we think that that's going to change any of the stuff we've discussed?
I don't think so. I can't think of anything fundamental from the consultation, which was enormous and far-ranging, but I can't think of anything that will change the claims culture, if you like.
I agree with you. I don't think the reforms are going to make much of a difference certainly not to the case law in terms of what you can take to the High Court and what you can't, what's more appropriate to the county court and small claims, the costs you can claim back. And just before we go to like a final summary from you on the bits, a quick one on your Trump case, because it was a great story.
So this case is in the public domain. So
yes, only what you're able to say publicly. We don't want to get you sued by.
Yes. So we were instructed by the golf course, which is just outside Aberdeen, which was purchased by Donald Trump and was very controversial because of the site was a site of scientific special interest, and there was a lot of negative press about that, aside from about Mr. Trump himself, who wasn't well liked in the area. So there had been a lot of activists on the golf course doing various things, and two of the individuals who were on the radar, if you like, of the staff were walking along the golf course, and one of them decided to take a pee on the golf course, or right next to the golf course, and the staff took a photograph of this with a view to reporting it to police, which they did, and she was actually charged, albeit never convicted of anything. And so she raised an action against the golf course for, well, this was the case that I mentioned earlier, because the ground of claim was that the golf course wasn't registered with the ICO. They'd just simply forgotten, they'd let it lapse, and they had CCTV cameras. So it was a very misplaced claim. But we did look into a very broad range of issues about whether or not it was personal data, whether or not it was the employer was the data controller, whether or not there was an exemption that applied. So there was, really interesting points. and given what was at stake reputationally for the golf course and its owner, who by that point was the President of the United States.
Wow.
The case had started, he was an unlikely candidate, and then during all the procedural hearings, he became the president. So by the time the case got to court, the media attention was intense. There were banks of cameras and photographers outside the court. But anyway, that's a personal privacy issue for me.
Yeah.
So the claim itself was unsuccessful, and it's all reported, so you can read about it.
Fantastic. We'll have a look at that.
Yeah,
So,
but there was no connection between the breach and the distress caused.
So that's the causation bit that we were talking earlier.
Exactly.
So thank you. So just as a last sort of 1 minute summary of whether people should panic, not panic, and what these cases might do, and then we'll wrap up there.
Okay, so the reason that I wanted to talk about these small claims was that I felt the big claims, the Morrisons, the British Airways, and all the fines that the ICO have issued were hitting the headlines, whereas actually for most organisations, it's these small, uncomfortable type claims that are probably causing the most consternation. So hopefully this has been a useful discussion of what to think about when you receive, or when a breach like this happens, how to react. And then if you do receive a claim, to think about it really carefully. Is there a basis for this in terms of a breach? And then is there a basis for this in terms of distress or damage caused? And do that analysis before panicking. That would be my good advice.
Well, Laura, thank you so much. We've gone way over time, so it's going to be a longer video because I want to keep as much of this in as possible, but it's going to be super helpful for our audience. Thank you so much. I knew this was going to be a great conversation. Thank you very much for coming on to Privacy Kitchen.
Thank you, Robert. It's been immense fun.